Today we'll be talking about guardianships and conservatorships. Let's start with what is the difference between the two. A guardianship is when there's an incapacitated person that does need medical assistance, meaning we need someone to take care of them medically and there's no powers of attorneys in place. Therefore, you would file a guardianship so that the court appoint you to be in charge of any medical matters for them. Whereas a conservatorship has to do with their finances. Again, if there are no powers of attorneys involved, you would need to petition the court to be the conservator of this person so you can help manage their finances for them. This is all in the event that the person is incapacitated. Obviously, if they are not incapacitated, they can fully sign a power of attorney to hand over these duties to someone else if they are of full mental capacity. So let's talk about what incapacity looks like. You do have to file what's called a medical professional report, and this is what it looks like right here. A medical professional report will include, this can be signed by a PCP, a nurse practitioner, a psychiatrist, psychologist, whichever it may be. They would include all of their names, addresses, and references, their license number. They would need to list what type of doctor they are. And what they provide us with is patient information. How long have they known the patient? When was the last time they saw the patient? It does have to be recent to file with the court. They do have to list any difficulties they have, whether they have a mental disorder, if they have a physical illness, if they have a chronic condition due to drugs or intoxication, cognitive disabilities, and so forth. Then they will need to describe to the court whether they believe they could get better, their condition will stay the same, or what their long-term goal is, including any treatment plans that they have in place. This will include physical therapy for cognitive assistance and as well as their medication. Aside from that, we need to list any type of impairments they have. Can they pay their bills on their own? Can they feed themselves? Can they live alone? And so forth. That all gets filled out by the physician as well. Now, aside from all of that, if a psychiatrist or a psychologist fills out the form, they do have a separate section that states whether or not they believe, based off their own opinion, if this patient will need to seek inpatient mental health, meaning they need to be put in a specific facility at any given point in time. Only psychologists and psychiatrists can fill this section out, not your standard nurse practitioner or MD. And if so, the court will take that into consideration as well. Now, let's talk about the process. So during the process, we would file the initial petition, and we would file this on behalf of the person wanting to be the guardian and conservator, and it must include the physician's statement. The court will then set a hearing date. They will appoint the incapacitated person a specific attorney to represent them, as they do have their own rights and responsibilities as well. There will also be a court-appointed investigator. Now, a common theme that I see is a lot of people think, well, if we're paying for attorney's fees, why isn't the attorney appointed by the court and the investigator covered in that? Those are completely separate entities, so they will invoice the petitioner for their services. Now, once they do their investigations and they interview both the petitioner and the ward, the incapacitated person, they'll read the physician's note and then determine whether, one, is the person filing the actual person who should be in charge of the incapacitated person, and two, does the incapacitated person in fact need a guardianship conservatorship? So once all that's determined and we go to a hearing, the hearing will ask for both attorneys' sides of the story as well as forms to be filled in with their investigations and their reports. So once that's all reviewed by the judge will make a determination whether a guardianship is needed, a conservatorship is needed, or both. Now, a lot of people also don't understand that when someone is incapacitated, they can't make legal decisions or healthcare decisions for themselves anymore. So therefore, a lot of times their driver's license will be revoked. If they had a driver's license, that normally gets taken away once the hearing takes place. They will also revoke their right to vote. So those are two items that people always seem surprised by, but it makes sense. If they can't make decisions on their own, they shouldn't be voting. They shouldn't be driving and putting other people at danger. You can always contact us if you have any questions for guardianships, conservatorships. We do get free consultations, and we do provide the physician statement to you to take to the doctor if you needed to get that filled out as well. The standard time frame for this, let's say we file for a guardianship and conservatorship, we normally get a hearing within 1 to 3 months. So a lot of people think that it's an instant thing that takes place. It is not. It will take some time to get that hearing. But once the hearing takes place, you're usually rocking and rolling, and by the end of the day, you have your orders signed by the judge stating you are in charge.